All right, that's what everybody's been asking for. These are the January 2025 changes to the North Carolina real estate forms. And first up is the exclusive right to sell listing agreement. This thing went from 13 pages to 7. So this is probably one of the first documents we've had in a while that got shorter instead of longer. But the Forms Committee took some time and made this document a little bit more simple and clarified some things to be in compliance with the settlement from last year. So let's dive right in. This is Standard Form 101 from the North Carolina Association of Realtors. On page 1, you still have your services provided, your fixtures, all of that, but there has been a box added where you can check that there are additional parcels that this agreement would cover. Make sure that if you've got that you're adding the exhibits so that extra parcel or more than one extra parcel will be included in the definition of property. I'm sure you guys know this, but when there are words in here that are capitalized, that means they're defined, and those definitions are very important. So making sure that you've got everything that's supposed to be included in the property captured under the listing agreement. This also has the opportunity to say, hey, this property might be currently listed elsewhere with another firm, but that expires on X date and time. This will kick in once that prior agreement has expired. I'd say the most important change here, though, is going to be in paragraph 7, where it comes to fees and costs for the services. And this was the most significant redraft, and this was because of the settlement, of course. It talks about how the fee is negotiable, and it's in all caps that the seller understands that the amount of compensation is fully negotiable. It's not fixed by law. It's set by every broker, every firm individually, and that's always been true in North Carolina. But this statement is intended to be conspicuous and confirm compliance with the settlement. So while it's not a new concept, just making sure you understand why that's in there and why it is so big and bold. It's really important that the seller sees that. Next, the breakdown for the firm's fee. So this is different. It used to be that, you'd say, all right, seller's paying 5% as a fee, and then the firm will cooperate with the buyer's agent and pay them 2.5% or 2% of that 5%. That's not the case anymore. In the listing agreement in 7B, when it says firm's fee, this is what the seller is paying to the seller's agent, to the listing agent. So this does not include any cooperating compensation. So whenever you're putting, what the seller agrees to pay the firm, that is what they're paying the listing agent. If they're going to be paying the buyer's agent anything, that will be in the next section, 7C. And this is where it's talking about cooperative compensation to other agents. So, you don't have to agree to that. A seller doesn't have to agree to that. They never have in North Carolina. But again, the form being redrafted to just make it really clear that it's compliant and that we've got the same procedures that are necessary to stay compliant with the settlement. But there's a checkbox for the seller to decide whether to offer cooperative compensation or not. And if they agree, in what way are they going to offer it? So are they going to give a certain percentage of the gross sales price? Is it going to be a flat amount, whatever that may be, but that you will choose based on the different boxes there. One of those boxes being that the firm will offer cooperative compensation as explained in the firm's policy, but that means you have to attach the policy to make it part of the agreement. And then in D, the total cost, this is where the seller can understand, all right, this is what it's going to cost me for the services, which will be what am I paying my listing agent? What am I paying a buyer's agent, if anything? And it will be this amount. A lot of the form, stayed the same or is just slightly out of order from what you're used to. There's still the information about home warranty, fixtures, etc., telling whether the firm is going to hold the earnest money or not. And then also dual agency. So this section's been redrafted just to make it a little bit shorter and more clear, but it still is going into detail about what dual agency is and giving the opportunity to allow the seller to say whether or not the firm can act as dual agent in any transaction involving the seller. And then if they can, are they saying that the same agent can represent the buyer and seller, or that it has to be a different agent within the firm? There's a series of disclosures that the seller needs to make, such as whether they're working with a relocation company, did they get this professional services disclosure form, have they owned the property for at least a year or not, going on and on, whether they're like, do they own the property? Is there a mobile home on the property? And do they own the property? If you're not involved in real estate, then you may be wondering, why the heck would that even be in there? They might be under contract to buy the property, then to immediately market it. So that's why there's a question to say, do you own this property yet? Then also asking whether the property is in a flood zone. Are there restrictions? These are all things that were already included in here, but the things that, it's kind of more organized as to them being in the same section of what the seller's disclosures are. And though this is not a change to the form, it's important to note who should sign the listing agreement. Anybody who's got to sign at closing. So if you're in North Carolina, you've got that pesky marital interest. So unless there's some prenup, postnup, separation agreement, a deed severing marital interest, some contract between the spouses to get rid of the marital interest, then if a person is married, whether or not they were married when they bought the property and whether or not their spouse is on the deed to the property, that person should sign the listing agreement. They should sign the contract, because guess what? In order to convey clear title, they're going to have to sign the deed and the seller documents at closing. So get them on everything that needs to be signed in order to make this all legit. So moving on to our next change, Form 201, exclusive buyer agency agreement. This one was just redrafted in October, but there were some changes in January. In this one, the updates were to mimic the language of the settlement and also help have that dual agency discussion. So for example, in the changes to Form 201, exclusive buyer agency, there's another reminder that a firm representing a buyer cannot receive compensation that exceeds the amount that's agreed to within the buyer agency. The settlement was explicit about that, okay, in your buyer agency, your buyer has agreed to pay you 2%, and then the seller then offers to pay 3% to the buyer agent. Unless that buyer agency gets amended to allow for 3%, the buyer agent cannot make more than the 2% that was agreed to in the buyer agency agreement. So just keeping that in mind whenever you're drafting these, and also making sure that you're having appropriate conversations with your buyers about that. The dual agency section has been changed to mimic how the listing agreement looks. So, basically replace buyer with seller, or seller with buyer in this document, and it looks exactly the same as the listing agreement does. Next is a new form. This form was also created in October. It's called a property showing agreement. This really came out of the fact that the settlement required you had to be in have some sort of written agreement with the buyer before you were showing property. Remember, though, that the settlement doesn't say if you're showing property on behalf of a seller. It's if you're working on behalf of a buyer to show property, you have to have a written agreement with them. So this property showing agreement was prepared to be kind of a one-pager of, all right, you want to go see this one property and you're not ready to enter into something more formal or more committed. Well, I will show you this property here, and this is what I will be paid for that service. Regardless of whether you put in an offer, regardless of anything else happening, then, this is what I'm going to be paid. Now, in this form, it does say if buyer does make an offer with firm's assistance, firm expects to be paid X amount. So that has been added. There's also a term of the agreement to tell you when the term expires. We can't have open-ended agreements here, so they have to expire at some point. And then as far as the showing services, you can get a fee for those showings as well. So even if the buyer doesn't make an offer, you can negotiate in this property showing agreement that you will be paid X amount of dollars for showing that property. And then there's also a section added here to say whether or not the firm can act as dual agent during the showing services. All right, and last one with a major change is the non-exclusive buyer agency agreement. This is standard Form 203. It kind of mimicked the changes to Form 201 last October, but the biggest change was in section 4.1, and before it kind of said that the buyer would not be responsible for paying a fee, but that's, you don't necessarily want to agree to work for free. So this non-exclusive buyer agency is explaining that this fee is fully negotiable so that you can negotiate to be paid a fee if the firm is the procuring cause of the sale. And it will say here in section 4, what that amount is going to be, when it's earned, when it is due and payable. And then the dual agency section in this one has also been updated so that it looks the same as Form 101 and Form 201. And those were the big changes for January. It's off cycle. We've had a couple off cycle changes. Usually we get these in July. So we got changes in July, we got changes in October, and now we have changes in January. And guess what? We're probably going to get some more in July. So we will keep an eye out between now and then to see if there are any more forms updates. While it can be a little bit head spinning to try to keep up with these changes that are happening more frequently, what I think it shows is that the forms committees are listening to you. So when you say the forms that we have don't fit our situation, they don't fit with the settlement, we don't know what to do with these. Well, guess what? They got redrafted to try to make that better, and they're being redrafted more frequently or updated more frequently in response to the feedback that's being given to the forms committee and to the people in charge of preparing those forms. So I would say keep your feedback coming to those people in charge as you learn more and as we, know how to navigate this world post NAR settlement. The forms will only continue to get better, but that is only if you continue to give your feedback. So I would encourage you to do so, and I will see you with the next round of edits.